You are watching Sorainen Public Procurement Academy. Stay tuned. When you enter Estonian public tender market, you might face yourself with a dispute resolution as well. For example, you might not agree with a decision the contracting authority has made, which negatively affects you, or there might be an instance where you are a third party, for example, a prospective winner in an Estonian public tender, and a competitor disputes the decision that you might be declared successful. You might not agree with tender conditions and you might want to dispute them as well. Or there are some other avenues of disputing amendments of contracts or the effectiveness of a public contract as well. So there are instances where you might find yourself facing a dispute. In Estonia, it's usually, let's say, 200 or 300 public procurement disputes a year, which are handled by the courts and the first instance review body. So it happens. But in this video, we'll give you an overview how to survive dispute resolution in public tenders in Estonia, and what to look out for, and more or less how to ensure that you might be successful there as well. The system in Estonia currently is a 4-stage process. We have an out-of-court review body, which is very similar to a court, but it's more or less an administrative organ. And then if somebody is not satisfied with the decision of a first instance review body, you have a 3-tiered court system up to the Supreme Court. Usually public procurement disputes end in the Public Procurement Review Committee because the committee is very professional. The members have been doing it for a long time, and their decisions are usually respected. So it's rare that disputes go on to it's rare if disputes go on to administrative court, then to the circuit court, and then the Supreme Court. So let's say about maybe 10% of decisions by the review committee are further disputed in the court system. The review body is a mandatory first instance review body, meaning that usually you have to go there as a first step. There is no stepping directly to the court system. There are exemptions for some sorts of disputes, for example, these that include governmental secrets and so on. These will be handled directly in the administrative court system, skipping the first instance review body. But let's say 98% of disputes land first in the first instance review body. The parties in Estonian public procurement dispute resolution are the contesting party, more or less somebody who has a problem with either with the decisions of a contracting authority or the tender conditions, the contracting authority or contracting entity, and third parties. Third parties are usually other bidders, especially those bidders who might be affected by the decision which will be rendered. Usually they are the successful or preliminary successful bidders, who therefore have a say also in dispute resolution as well. The Public Procurement Review Committee and the courts will handle disputes which concern your subjective rights, meaning that the only subjective right you have is the interest towards the public contract, and they will not handle any disputes that don't matter to you, for example, based on public interest and etc. These kinds of disputes might be a subject matter for the Ministry of Finance to resolve, which has a unit which deals with, let's say, disputes arising out of public interest concerns, and so on. But usually a foreign bidder does not interest itself in questions of whether something is in the public interest in Estonia or not. So this is a rare occasion if a foreign company decides to protect their rights in the Ministry of Finance instead. The deadlines for contesting the actions of contracting authorities are very short because Estonian dispute resolution system is one of the fastest, or maybe even the fastest in Europe, meaning that the standard deadline for disputing the decisions of a contracting authority is 10 days. If the estimated value of a contract is below national thresholds, it's 3 working days. If you want to dispute tender conditions, then this requires you to submit a contestation notice 2 working days before the submission date of bids or the applications. So this means that in some extreme cases, let's say you might need to submit a contest or a dispute on tender conditions on the same day when the tender is published. So never leave it too late. So if you find anything that's a condition that does not suit you or does not allow you to submit a bid or an application, then if you have time, turn to the contracting authority and ask politely whether they might be interested in changing it. If the contracting authority answers in the negative and you have no other avenues, then you file a notice or contestation notice to the Public Procurement Review Committee, and then the procedure will start. There are also differences on the deadlines for specific tender procedures, but these are the main ones here displayed on the slides. In case of bigger contracts, it's usually for decisions, it's 10 calendar days. So this is a rule of thumb you need to keep in mind. The review system requires you to pay a state fee. There are 2 types of state fees. If the estimated value of a contract is above the European threshold, which is different on different subject matters. For works, for example, it's around 5.5 million at this time, but for goods and services it might be around a couple of 100,000. Then the state fee is 1,280 euros. If the estimated value is less than the European thresholds, it's half of that, meaning 640 euros. If you go on further into the court system, if you want to file a appeal on the decision of the review body, for example, then you need to pay the same kind of state fee. But the state fees are usually not the most expensive elements of the dispute resolution system. You might want to get yourself a lawyer who knows what he or she is doing, and you might be facing yourself with lawyer fees as well. Thankfully, Estonia also uses the loser pays principle. So if you are successful, then your lawyer fees or legal fees might also be reimbursed in part or in full, depending on how big they are and whether the court or the review committee finds the costs to be reasonable. If you talk about the practicalities of the dispute procedure, then As you can see from the slide a few years ago, I looked into the statistics in the first instance review body, and the median time that it takes from applying for the decision and then having a decision is 22 calendar days. Might be longer at this time, but statutory wise, it cannot be more than 30 or 35 days. So in any case, you will get your decision in a month. In the court system, there are similar deadlines. In the first instance court, it's enshrined in law, which means that the decision has to come in 45 days. The second instance court will follow the same deadline of 45 days, and the Supreme Court might take around 4 months if the case is heard. So all in all, you will get a final and binding decision if you decide to go through all the pyramid, usually in less than 6 months. As already mentioned, filing a dispute on the decisions of the contracting authority is mostly a 10-day deadline, could be less. And then what happens next is the review body will ask you for, or you or the contracting authority, depending on who you are exactly in the procedure, will ask for comments, in written comments in 3 days, 3 working days. After that, it will be decided whether it's an oral or a written procedure. 95% of the times it's the written procedure. Even if you ask for an oral procedure, you might not get one. So because that's the discretion, because that is the discretion of the review body. But on a side note, if you ask for an oral hearing in the court, there is more probability you will get an oral hearing. But most of the cases, even in the court, are also in public procurement matters decided in a written procedure. So after 3 working days where the comments have been submitted, the review body will decide whether to have an oral hearing or a written procedure, and will give another time or another deadline for submitting of written comments, for example, or will give a deadline for an oral hearing. And in simple terms, it's more or less, if you are the contesting party, you will file a complaint, a dispute or an appeal, whichever we call it, and after that you have another round for written comments. You have 2 chances to prove your case, and the opposing parties, for example, if you are a third party, you have the possibility to answer the dispute and then also answer the written comments of the contesting party as well. So each party in the first instance review body has essentially 2 rounds of submitting documents, after what the review body will decide the case usually in a week or a couple of weeks. The procedural costs were already discussed, but more or less we use the loser pays principle. If the contestation is granted in full, you will get back your state fee. It's obligatory, you don't even have to ask for it. And then you will get back your legal fees in a reasonable amount. They could be in full, they could be in half, somewhere in between usually. The same principle also applies in the court system. And but I would say from professional experience that it's quite rare that you will get all of your legal fees back. But in any case, if the contract value is large, the legal fees don't really amount to that much of an outlay in any case. So if the contestation is granted, let's say partially, you will get your state fee back partially and your legal fees back partially. So as you would expect things to go in an ordinary court system. ain't that much differences in how procurement cases are handled in courts compared to a public procurement review committee. The court procedure is a bit more formal with special electronic systems where you file your documents, your complaints. In case if it is in the first review body, you will just file an email to the email address of the review body, and then everything else is also carried out via emails. The court procedure rules are also obviously more detailed than the ones which apply to a public procurement review committee, but there ain't that many differences between the court procedure and out-of-court procedure. And that was shortly all about how public procurement disputes are handled in Estonia. I hope you never end up in one, but if you do, I hope you will be successful, and I hope this presentation will help you in that. Thank you. You are watching Sorainen Public Procurement Academy. Stay tuned.